Welcome to the Just Settled podcast. I'm Dan Taft. On today's episode, we have with us an incredible attorney out of the Bay Area, San Francisco and Oakland, Micha Liberty of Liberty Law, who is an awesome sexual abuse, sexual assault, and sexual trafficking attorney. So welcome to the show, Micha. Thank you so much for joining us here today.
Thanks for having me, Dan. It's a pleasure.
And this case that we were talking about a little bit before, obviously very sensitive, very sort of a lot of layers of emotional difficulty just around it. And the work that you do is incredible. You're such an advocate and someone who helps people, vulnerable people, really, in these cases. So, thank you for the work that you do, first of all. And yeah, we can kind of dive right in here. How did you first, you can kind of give us an overview of this specific case that we were discussing, how you first learned about it, and your first kind of thoughts when it came across your desk.
So the case is called Brennan B. So we'll just talk about it like that. And the case was referred to my office in 2013. And for a very long while, I was one of the few lawyers in California doing sexual assault cases on behalf of special needs individuals. There is a whole litany of challenges when you represent people who are not neurotypical. And so that's always the first thing that I think about. How are we going to get the information from the client in order to build the case and prepare the case? Most of my cases come from lawyers who don't handle the types of cases that I do, or defense counsel that I've gone up against who, maybe thought it wasn't super pleasant to litigate against me, but they appreciate my tenacity and the passion and time I put into these cases. So anytime a case comes in, I always have a conversation with the guardian or the parent to just kind of get a lay of the land. And what I learned was that Brennan, at the time, I think he was 14 or 15, had gone to the bathroom at school at De Anza High School. The defendant was West Contra Costa County Unified School District. He was supposed to have someone watching him because of his special needs. And he was let into a bathroom where another special needs student was in there. And that special needs student sexually assaulted, sodomized, raped my client. It turns out that perpetrator, and it's terrible to call the quote unquote perpetrator because he was also special needs and he didn't have the supervision that he should have had. So there's victims all around in these cases. And just because someone engages in this bad behavior doesn't mean, they're criminal. But he had just 2 weeks prior been caught sexually assaulting a girl, a female student who was special needs as well, in the girls' bathroom. And so these two students should have never been in the bathroom together at the first place. And so that was the initial threshold, because I have had a lot of experience, even at the time, dealing with some of the best experts who can help extrapolate the data from special needs or, neuroatypical witnesses and plaintiffs. I took the case and I met Brennan and I met his family, and they are like family to me today because we were together so long working on this case and then a subsequent case that grew out of this case.
Yeah, and you said this took place in 2013, right? So it was a while back, or the incident was a while back.
Correct.
Did you have concerns when you first learned about it, or any uncertainties about the outcome or how the case might unfold as it went on? What were your first kind of things that you were, identified as potential challenges or things to kind of watch out for in terms of any uncertainties like that?
Well, one of the first things when you represent sexual abuse victims against school districts is an immediate concern as to whether or not the district had conducted an appropriate investigation. West Contra Costa Unified School District was actually under a consent decree from the U.S. Department of Education Office of Civil Rights. And that report was super helpful when we were gathering facts to prepare the complaint. But it's important to take a look at what else has gone on in the district and where you can get corroboration, because time and time again, and I'm not necessarily calling foul play, but time and time again, important documents go missing, even when they're scanned and saved on a computerized system. So there was at a local high school, Richmond High School, a gang rape a couple of years before, and the U.S. Department of Education came in and set some guidelines, and forced the district into a consent decree. So we were able to obtain documents from the U.S. Department Office of Civil Rights, and get what gaps the district had in terms of its own documentation. So that's really the first step. The second step is trying to get a handle on, who could have known, who could have done better. And, for me, one of the initial decisions is, who do we name as individual defendants? What
Right.
did the superintendent know?
Mhm.
What does the actual teacher in the classroom know?
Mhm.
And what do, importantly, the paraeducators know? And how well do they know my student? How well do they know the other student who conducted or perpetrated the abuse? So it's a lot of kind of fact finding as much as you can to lay out a cohesive story. But I have to tell you that as soon as the pieces fell into place,
Yeah.
they fell as I assumed they would, just having experience in this area. And I was very confident about our ability to prevail past MSJ and at trial, based on what we knew before we even filed the case.
In terms of like the timeline from how long did this case run? You said 2013 was the incident.
Yeah, it resolved in, I think it was 2016.
Okay.
And it was hard fought litigation. These cases, when you have a school district, everybody knows a tiny little piece of information. So you end up taking 30, 35 depositions before you even get to experts. It's
Right.
time consuming, expensive, but it's very important. I look at preparing for trial like I'm building a house. And so each deposition is another brick to the foundation of what we're going to present at trial.
Want to share your settlement success stories? Join us as a guest on the Just Settled podcast. Visit our Instagram at Just Settled Case and click on the link at the top of the page to set up your interview today.
So we had gone to a mediation, and I think we were about 4 months from the trial date in that case, the first case, and the case didn't settle. And we sent a 998, assumed the defense was going to object or, just not respond. And then we learned through an interview with one of our experts who was kind of preparing his trial presentation, met with the client again to just do a check-in, because it had been about 9 months since they had had any interaction. And Brennan reported additional abuse in a bathroom. And so the next strategic decision was, what do? Do we pull the 998? We don't want them, if there's more abuse, the value changes. So I called the defense lawyer and said, here's what we know. Would you like to have a global discussion? And, or should we just file a 910 claim form and, litigate the second case? And I have to imagine they regret this, but they said, no, you're going to have to file a second case. So we did.
Okay.
And we settled the first case, and we were off and running to the second case.
Wow. Okay. So there was kind of like two concurrent, they overlapped to a degree, right?
Exactly.
Yeah, that's interesting. And then
the second set of abuse, the time frame. I mean, it's hard when one of Brennan's challenges is chronology or when something happened. But as best as we could figure out, it was fairly clear based on other things that Brennan had said and other things that helped identify a time frame that this second abuse definitely happened during the initial litigation phase. So even during litigation, they weren't properly monitoring him or keeping him safe, which is shocking.
Terrible. And then, so when did you kind of know that obviously that first one settled, and then you're in the second one, right? When did you kind of have a sense that second one, that they were going to settle that and not did that go to trial, or did that also settle outside of court?
It also almost went to trial.
Okay.
So what happened was we filed in state court, and listed civil rights claims, state law civil rights claims.
Okay.
The defendants, and this was kind of a trend at the time, were bringing demurrers to these federal civil rights claims, which essentially say you can't discriminate against someone or treat them poorly or abuse them because of a disability. There's obviously a federal counterpart to that statute. The one we relied on here is called the Unruh Act. It's a state law. It's kind of like partially the equivalent of the Americans with Disabilities Act. So they made an argument. Our state court judge, who was fairly new to the civil bench at the time in Contra Costa County, granted their demur. We took a writ. The writ was accepted, which is very, very rare, because we didn't want to. We were frustrated that, this poor child had been through all of this. It was clearly discrimination based on his disability. They weren't taking seriously their obligations. They weren't taking seriously any attempts to report. They were just kind of shining it all on, thinking, oh, we got rid of that last case. Forget it. We don't have to pay attention to this. So we then filed a companion case in federal court. So we could take advantage of all the federal civil rights statutes, which was very helpful. So we were kind of litigating on dual tracks.
Okay.
We eventually had a settlement conference with a wonderful magistrate judge here in the Northern District. And that case got settled. So we ended up dismissing the state court case, consolidating it with the federal case, and settling through the federal court system.
Wow.
Because that was the way to get it done.
And that is some process. I don't think I've ever heard that before. That the way that kind of played out there.
Listen, once I've got, someone in my crosshairs, I'm going to look for every avenue to get them to recover. And what's interesting is the writ was still pending. And so when part of our agreement to settle the case, of course, is dismiss all the litigation, and we tried to dismiss the writ, and the Court of Appeals rejected our dismissal. Okay. And so we thought, okay, maybe they just didn't get what we were trying to do. We tried again, rejected our dismissal. They wanted to write an opinion on this issue. It ended up being terrible for people with disabilities, unfortunately. And we took it up to the Supreme Court, again, not taking, no for an answer. But unfortunately, now the law has changed for people with disabilities.
And then can you speak to that actually for a moment, just in terms of what that law change is?
Yeah. So the Unruh Act was written by a politician named Jesse Unruh in the 60s, who was like a civil rights pioneer and legislator here in California. And it was meant to have the same protections of the federal statute, the Americans with Disability Acts generally, apply to state law causes of action, because it's really important when you're talking about civil rights that we have here in California our own state laws that provide those same protections. So if we want to avail ourselves of the court system and have a jury of our peers here in California, we can do that using California law and don't have to go to the federal court system using federal law. So we have a couple of civil rights statutes, which are the equivalent of those pending on the federal level. And the Unruh Act had been modified and changed, as legislators are wont to do. And they added some language that applies the Unruh Act to any kind of business whatsoever. Okay. And what they found was that although some cases, and this has been kind of rubber stamped or endorsed and used in federal jurisprudence for the past 28 years based on a case called Sullivan that the Attorney General litigated, which says ADA is to UNRU as UNRU is to ADA, and it applies to schools. Well, the first district here in California and the Supreme Court said, well, the first district said no. A school district is not a business. The Supreme Court said this statute's not great, so the legislature should modify it.
In today's digital landscape, a strong social media presence holds significant importance for legal professionals. Recognizing this need, Practice 360 by LegalSoft is pleased to announce an exclusive promotion offering a comprehensive law practice social media solution free of charge for 30 days. Practice 360 is the all-in-one solution to elevate your law firm. Access a suite of services including personalized mobile apps, website development, PR, and social media management. With everything centralized, say goodbye to juggling multiple providers. Elevate your firm's success with Practice 360 today. Wow, yeah, that is it's all a lot of stuff that it was not aware of, so it's interesting to kind of learn about it. In this case, as it kind of got towards where you were in the settlement process, how did that negotiation kind of go back and forth to that process? How did it unfold? I'm assuming that the defendants were trying to, obviously do their job, which is kind of minimize. I don't know how they minimize liability in this case or compensation, but I'm sure that was what they were trying to do. How did you fight against that? Like, how did you advocate for your client's interests? And just how did those negotiations go?
Well, I think we were all smart to get in front of a good settlement judge. I think that's a big piece of it.
Okay.
And again, the first case and when the second case started was before the Me Too movement. And, for all its warts, because there's definitely a backlash, which was not helpful to my clients when everything broke with Harvey Weinstein. There really is a marked difference for those of us who've been doing this work. I've been doing it for 23 years. So before the Me Too movement, credibility was an issue. Someone like Brennan not being able to testify for himself would have been a hindrance to his claims. We used to hear really ugly arguments when we're talking about special needs survivors, like, well, do they really even understand what's going on? Or how can they really, feel harmed by this? They can't articulate it. I mean, really
Terrible.
dehumanizing and disgusting behavior. So we did what we always do, which is focus on the damages and focus on how the abuse, the string of abuse impacted Brennan. And I want to tell you just a little bit, if I can, about the second perpetrator, because it's important. Nice. So this gentleman, we're like 2 weeks from trial in the second case, and I get a phone call from the Pinole Police Department saying, we arrested this man. He worked at a group home for autistic adults, and he was caught sexually abusing several of the male residents. We brought him in and Mirandized him, and he spontaneously confessed to sexually abusing your client in the gym on the De Anza High School campus. And it was the guy the district literally hired for Brennan after the first case to keep him safe.
Oh, no.
To take him to the bathroom, to watch him in the hallways. And so this is what they did. They just, obviously unknowingly, but you would think they would do a little bit more when they're assigning an adult male to watch Brennan. So we had to, push off the trial date, and then we were off and running with the federal and civil going on. But it's important.
The school is liable in that case, right? I mean, yes.
Correct. Yeah, he's an agent. And there was notice that they were, the whole purpose was that they need an adult to be with Brennan, so he's not sexually abused again. So, unfortunately, they were just like, here's the bare minimum. We're giving you someone. We've met our obligation under the rules related to IEPs. Those are the individual education programs or plans that special needs students get. And unfortunately, most of the time, the districts, it's the bare minimum, and that's all they're going to pay for, and that's all you're going to get.
What was the final outcome of these settlements? Because there were two separate settlements ultimately, right? So what did those look like, and how did that sort of help your client? Obviously, this is something that's so difficult to move forward from and kind of overcome that challenges. But if you could speak to just kind of what those settlements were and how it helped, him and his family.
Yeah. So the first one was they did sign the 998, which is a rare occurrence, and I think every trial lawyer that gets a signed 998 back thinks, oh, I left money on the table. But I think it was because they knew the second case was coming, so that they accepted our 998. I think it was 1.43 million, and then the second one was a negotiated a settlement through the magistrate that we used here in the Northern District, and that was 2.5. And what I'll say is, it totally changed the life of Brennan. He was able to afford to get all of the additional services he needed, applied behavioral therapy. One of the things that he was needed to get was sex ed, for lack of better term, from someone who could teach that to someone with autism, someone who was special needs, because working through what happened, he would say this guy, the man, he was a bad man, and people who looked like him, he was either drawn to them or would try and touch them, or recoil. So there was just a lot to work out. And when you have a neurodivergent brain, the way you process all of this kind of information and trauma is going to be so different. So it allowed for the mom to bring in all the specialists. And, this was a single mom. Brandon's mom was a wonderful woman, and she was working for the district during all of this litigation. She was a paraeducator in a special needs classroom. And she learned about autism and, understood, how to deal with autistic children, unlike a lot of the other paraeducators at that school district.
Yeah, wow, this was incredible case to hear about, and I'm sure their family and Brennan feel so fortunate to have you defending them and helping them, because you did a lot of amazing work here. So thank you, Micha, for sharing this with us, and thank you for joining us on Just Settle today. I hope to have you back soon. And well, again, anybody in the Bay Area, San Francisco, Oakland, looking for an incredible attorney for sexual abuse, sexual assault, sex trafficking, Micha Liberty Law is where you can find her.
Thanks so much. Thanks for having me, Dan.